Hello, welcome to the League of Women Voters Candidate Forum for Magisterial District Judge for 05242 that covers the city of Pittsburgh's wards 26 and 27 and encompasses communities of Brighton Heights and Perry North. My name is Judy Clack, and I am Voter Service Director of the League of Women Voters of Greater Pittsburgh, and I'll be moderating tonight's event. The League of Women Voters is a nonpartisan organization that neither supports nor opposes any candidate or political party. Rather, we are dedicated to facilitating the informed and active participation of all citizens in government. This forum is being conducted by teleconference and will be streamed in its entirety on our Facebook page beginning on Thursday, October 14th at 8 p.m. and thereafter posted on the League's YouTube page. To access both our Facebook and YouTube pages, just go to our website, lwvpgh.org, and in the lower left-hand corner, there are icons you can click on to get to those recordings. You may share those recordings on your own Facebook pages. What is a magisterial judge? The magisterial district judge represents the first rung in Pennsylvania's legal system and is responsible for a variety of offenses, ranging from traffic violations and disorderly conduct, truancy and drug possession, theft and landlord-tenant disputes, and more serious issues like setting bail or granting protection from abuse orders and issuing arrest warrants and search warrants, in addition to performing marriages. Magisterial judges serve a 6-year term and must run for re-election. Now, a few specifics regarding the format for tonight's forum. We're going to have about 60 minutes to ask questions of each candidate, who will then give a closing statement. A coin was tossed earlier by the League of Women Voters to determine who would go first, and Mr. Scorpion won the toss. Each candidate will have a chance to answer each question, and each person will have 1.5 minutes to respond. There will be no time for rebuttals. However, if a candidate wishes to rebut a remark, they may use time in their next answer to do so. I will be asking candidates questions in a rotating manner so that they each will have to answer first the same number of times. Questions have been gathered from a variety of sources, from the public and from League of Women Voters members, and they have been reviewed for relevance to the position being sought, duplication, clarity, and civility. Candidate answers will be timed, and candidates will be advised when their time has expired, although they will be allowed to finish a sentence once started. Please remember, these candidates are your friends and neighbors who have stepped up to serve their community. It is my honor to introduce them now. First, we have Mark J. Scorpion from the Republican Party and Leah Williams Duncan from the Democratic Party. And the first question will go to Mr. Scorpion. What are your qualifications for being a magisterial judge, and why are you running for this position?
Thank you, first of all, to the League of Women Voters for this opportunity to speak. My qualifications start with, I've been an attorney for 30 years, having litigated thousands of civil and criminal cases in local, state, federal, and appellate courts throughout the state of Pennsylvania, primarily in Allegheny County, but also in surrounding counties as far north as Erie County and as far south as Greene County and all the counties in between. I've also served on numerous occasions during my 33 years as an attorney as an arbitrator, which presiding over cases in the Court of Common Pleas, basically presiding over the same types of cases that regularly appear before magistrates.
Thank you. Ms. Duncan, the same question.
Thank you, and I also thank the League of Women Voters for this opportunity to speak with you. I am Leah Williams Duncan. I have been an attorney for 25 years, and in those 25 years, I have practiced law in every division of our Court of Common Pleas, the Civil Division, Criminal Division, Orphans Court, and the Family Division. And for the last 20 years, I've presided over a courtroom in the Family Division. I conducted hearings in matters of child support, family support, civil and criminal contempt. I believe this uniquely qualifies me to serve as magisterial district judge. Again, I've been presiding over approximately 1,000 hearings per year. So in a 20-year span, I've heard over 20,000 legally challenging and emotionally charged cases, if you can imagine, in the Family Division. I am doing this because everything that I've done at the county level has really uniquely prepared me to serve at the magisterial district judge level. And I welcome the opportunity to come back to my community to bring my experience, my education, my commitment to justice, and to serve on the front line. I welcome bringing that back to my own community. Thank you.
Thank you. And now we are going to go right back to you, Ms. Duncan, to be the first to answer the next question. So you're on the hot seat first.
Okay.
How have you volunteered your time in community service, and how could that experience impact you as a judge?
So, well, I volunteered my time. Currently, I volunteer as a consultant with the Fathers Matter Family Support Group. I also volunteer my time, or I volunteered my time as a commissioner on the City of Pittsburgh's Human Relations Commission. I'm very active with my church, serving the community in different capacities, whether that be feeding, clothing, what have you. And it serves me as magisterial district judge because it gives me that connection with the community. And that's in addition to, my legal experience and my legal expertise. I've also participated in law forums, to educate the community in the operations of the court, and also just understanding how our system works and understanding the law. So I've reached out on many levels, especially I would say the work that I've done with the Human Relations Commission, which combats discrimination in all forms. And growing up in the 26th ward and living in the 27th ward, I've been a long time servant of my community. That's where my heart lies. That's where my children are. That's where my entire family, including my 89-year-old mother, still resides. So my volunteerism has always been about doing what's best for the community.
Thank you. Mr. Scorpion, do you need the question repeated?
Please.
How have you volunteered your time in community service, and how could this experience impact you as a judge?
Well, I've volunteered as a coach, baseball coach, basketball coach in the community. I've also been active in my church, serving as everything from a janitor to a lector on occasions. My situation as far as public service is a little unique because like Ms. Duncan, I have an 89-year-old mother, but she lives with me, and she is a stroke victim. And so she requires quite a bit of my care. So my public service has suffered for the sake of caring for my elderly mother.
Certainly. Thank you. Thank you. Okay, the next question, and this will come right back to you, Mr. Scorpion. And this one is a long one. Persons coming to magisterial court may be seeking resolution of a landlord-tenant dispute, may be seeking emergency relief from a protection from abuse order, may be facing arrest, or may be seeking resolution of a monetary claim. As a result, these people may be under considerable stress and facing uncertainty. What are the skills and personal characteristics that you possess that show you have the judicial temperament to assure all persons appearing before your court will be treated with dignity and respect, and that they will understand how the court will carry out those proceedings?
First of all, it's important to remember that every party comes into court cloaked in the cloak of the presumption of innocence. So everybody starts off on an even footing when they come in. My job as the final arbiter of facts in the law would be to make each person feel that they're going to have an equal opportunity to be heard. A lot of us are familiar with the picture or the statue of Lady Justice, and she holds the scales out in front of her, and those scales are balanced, they're even. And she also is blindfolded, and that signifies that the law is blind to race, color, national origin, sex, or any other socioeconomic factor. So it'll be important to let them know that as much as this might be an adversarial situation that brought them there, it doesn't require us to demonstrate any animus.
Thank you. Thank you. Ms. Duncan, would you like me to repeat the question?
Please, I don't want to leave anything out. Thank you.
Okay, yeah, that's a long one. Persons coming to magisterial court may be seeking resolution of a landlord-tenant dispute, seeking emergency relief from a protection from abuse order, may be facing arrest, may be seeking resolution of a money claim. As a result, they may be under considerable stress and they are facing uncertainty. What are the skills and professional and personal characteristics that you possess that show you have the judicial temperament to assure that all persons appearing in your court are treated with dignity and respect, and that they will fully understand how the court will carry out those proceedings?
Thank you. And you know, the court can be a scary place because of its adversarial nature. In the past 20 years, I have had the opportunity, and this is, you know, a very unique opportunity to hone and develop those skills to first start by introducing myself and just explaining a little bit about the process, you know, what's going to happen, what my role is. If there are attorneys involved, explain what their role is in the court proceedings. I've then, you know, made it my practice to listen to both sides carefully and just very, very strongly listen to both sides before making a decision. It's very, in my courtroom, well, actually bittersweet. I had to leave my job of 20 years, so I'll keep saying my courtroom, but I'm actually not there anymore. But in my courtroom, it's not unusual for, you know, parties to come in either feeling defeated or feeling very much, you know, at odds against each other. I've developed my skill to immediately, you know, put that at ease, to put it to rest. I am proud of my reputation in my courtroom. I think the attorneys who appear before me will tell you she's firm, but she's also fair. And just on this Sunday, I ran into a gentleman who had been in my courtroom some 15 years ago, and he thanked me for being fair with him and putting him at ease. And that is my reputation. That's what I've done for the past 20 years, and that's what I look forward to continuing to do.
Thank you. And now right back at you, Ms. Duncan. How will you handle the imbalance of power you will commonly see in your court between those who can't afford an attorney and the opposing party that either has the resources to hire an attorney or is a member of law enforcement?
That's a really good question. I thank you for that. You know, and again, in my courtroom, I've seen parties who had an attorney, and I've seen attorneys not do so well for their clients. And I've also seen clients who were pro se do a wonderful job. So, you know, the imbalance of power isn't so much dependent on the attorney or the attorney representation. I think it's dependent on the decision maker and the fact finder, that being me. So, you know, what I have to do and what it is my job to do is to assess the relevant facts and to apply the law. If I do that, and when I do that, then there is no imbalance of power, whether or not one side is represented or one side, you know, the other side is not, or if we have two pro se litigants, or if we have two attorneys who want, you know, want to go after each other. There's no imbalance. It's been, you know, my practice and my job to ensure that there is no imbalance of power in my courtroom based upon representation. And that's just part of the job. You can, you know, you can say that's what you'll do, but I know that that's what I've done for the past 20 years. It's a skill that I have developed. It has to be polished, but I'm very happy, and proud to be able to say that, that's what I've done on a daily basis.
Okay, thank you. Mr. Scorpion, do you need the question repeated?
If you don't mind.
No. How will you handle the imbalance of power you will commonly see in your court between those who cannot afford an attorney and the opposing party that either has the resources to hire an attorney or is a member of law enforcement?
Well, once again, each party enters court cloaked in the presumption of innocence, so that both enter on an even footing, regardless of their socioeconomic status. To those litigants who feel that they would like representation or need representation, but find it unaffordable or unattainable, I would educate them first as to the availability of legal representation through Public Defender's Office, the Neighborhood Legal Services, and Bar Association pro bono programs. Ultimately, and Ms. Duncan alluded to this, any perceived power in a legal proceeding is vested in the court, following the court's careful examination of the facts and a fair and impartial application of the law.
Thank you. Okay, next question. We'll start with you, Mr. Scorpion. And this is a similar one. Some feel that law enforcement has an undue influence in our court system in general. How would you balance the court's relationship with law enforcement with the rights of the defendant?
Again, in every proceeding that I've been involved in over 33 years, dealing with a defendant and a police officer at whatever level, state, federal, or local, everybody comes in to court presumed innocent until proven guilty. Obviously, people are intimidated by police in the street, in their courtroom especially, but the court has to turn a blind eye to the status of the police versus the status of the other party and apply the law according to the facts, regardless of who is dressed in a uniform and who is not.
Thank you. Ms. Duncan, shall I repeat the question?
I think I have this one.
Okay.
Thank you very much. So our caption on a criminal case is the Commonwealth versus whomever, the defendant. The Commonwealth, the police, who are represented by the police, the district attorney, they are a party in that action, just as the defendant is a party in the action. Both parties in my courtroom are treated equally, treated with due respect, but there is no favoritism for the badge. There's no favoritism for the uniform. There's no favoritism for the defendant. There are two equal parties who walk into my courtroom. I assess the facts. That's the job, as a fact finder. I assess the facts, assess the relevant facts, and I apply the applicable law. I apply the law of the day, at that time, appropriately. So I don't any favoritism or any perceived favoritism in favor of one party or the other. And I hate to keep saying the same thing, but I found the ability to kind of work through what's relevant and what's not relevant, and definitely to not allow any personal thoughts or any personal positions or anything of that nature to have any influence whatsoever in my decisions. And I ran into someone while I was out campaigning who was not very happy with the decision that I made in her case. And I instructed her, I said, you know what, if you ever walk out of a courtroom and you feel that the right decision wasn't made, then you appeal. And I'm glad that we have that, that next level, because sometimes mistakes are made, but people are protected when they exercise their rights.
Thank you. I already went to you, right, Mr. Scorpion, on that one?
Yes,
I'm
ma'am.
getting lost.
Yes.
Sorry. Okay, so back to Ms. Duncan. This is about truancy.
Okay.
Since a magisterial judge deals specifically with truancy cases, how do you plan to support both the school's needs and the needs of students who may not be regularly attending school?
Thank you for that question. I have actually taken the opportunity in the last few months to sit in on hearings at the magisterial district court level. I sat in with one of the judges or magisterial district judges who's now subbing for the recently retired Judge Ravenstall, and also in the courtroom of Magisterial District Judge Tom Caulfield. And I have begun, I've observed how they handle things. I've taken what I like and, kind of decided what I probably wouldn't do. But the other thing that I've done is reached out to neighborhood agencies, civic groups, people of that nature. And even I've received some calls from a few of the schools, and just, started to develop those relationships that'll make that job easier so that we can, find out what's going on in the home. If we have more than, one child in a family who's truant, then it's probably a family issue. But partnering with Northside Partnership Project, I've made a connection with them, Center of Life, Ozanam, just, trying to be proactive so I can put those relationships in order. And I found out that in the city of Pittsburgh, all of the truancy cases actually come to my district. So whereas I thought I had to form relationships with Northside groups, I'm actually forming relationships with groups across the entire city. And I have been enjoying that, and I look forward to those relationships and just serving our children.
Thank you. Mr. Scorpion, shall I repeat the question?
If you would, please.
Sure. Since a magisterial judge deals specifically with truancy cases, how do you plan to support both the school's needs and the needs of the students who may not be regularly attending school?
Thank you. Certainly, truancy is a community issue, a community problem, if you will, that requires cooperation, partnership among many different organizations. Certainly, the school must work with the families, but ultimately, we have to really examine the circumstances that are leading to the truancy. We really have to get to the heart of the matter to see what issues are causing this particular individual youth to miss school on a regular basis. Obviously, every goal after that should be aimed at returning the student to the classroom after having consulted with family members, after having consulted with school administrators, and after having consulted with any social organizations that maybe be able to provide help based on whatever the particular issues that the youth is dealing with. That's it.
Okay, thank you. The next question is going to be about bail, and we'll start with you, Mr. Scorpion. Magistrate judges are authorized to set the terms of release and whether to set bail. The forms of bail authorized under Pennsylvania law include released on own recognizance, cash bail, and in some cases, electronic monitoring. What factors will you consider in granting and setting bail amounts for defendants?
Well, first of all, the Pennsylvania Constitution and the Pennsylvania Rules of Criminal Procedure are clear as to what factors should be considered by members of the judiciary when determining pretrial release or the amount of bail or the conditions necessary for bail. The Pennsylvania Rule of Criminal Procedure 523 sets out parameters that must be considered in deciding on bail. And those include the nature of the offense, whether there are mitigating or aggravating circumstances, the person's connection in the community, family-wise, their job situation, their financial situation, their whether they've had a previous run-in with the judicial system, and if they were offered bail, how they reacted to the bail. Did they abide by the terms of the bail and the conditions that were set? So bail is, again, keep in mind that it's prerequisite use is to just guarantee attendance at hearings and trial, and it's not punitive in nature, nor should it ever be.
Thank you. Shall I repeat the question, Ms. Duncan?
Please.
Sure. Magistrate judges are authorized to set the terms of release and whether to set bail. The forms of bail authorized under Pennsylvania law include released on own recognizance, cash bail, and in some cases, electronic monitoring. What factors will you consider in granting and setting bail amounts for defendants?
Thank you. And it's certainly each case has to be looked at for its own merits. Each defendant, each individual has to be assessed, based upon their, own factors, as have already been outlined by Mr. Scorpion. The only thing I would, and I don't know if this question is going to come up because it was in the questionnaire or that we were given for the Vote 411. So I may be stepping into the next question, but you asked if we would be willing to use the assessment tool. And with all the factors that are outlined within the assessment tool and all of the information that's, available to us, as Mr. Scorpion said, connection to the community, employment status, family status, things of that nature. The only one that kind of, gives me a little bit of a pause, and also maybe the issue with the assessment tool is, as Mr. Scorpion put it, previous run-ins with the law. And I think I need to go a little further and look at actual arrests, look at charges and the outcome of those run-ins. But certainly all the factors that have been outlined and the factors that are outlined by law, I would definitely take into consideration specifically as they are specific to each individual.
Thank you. Okay, the next question is pre-trial and diversionary programs. And we will start with Ms. Duncan. What is your experience in working with pre-trial services and diversionary programs? Do you support alternative sentencing programs? Why or why not?
Absolutely. In my experience, and as I stated, for the past 20 years, I've been sitting in the courtroom in the family division, but certainly we have incidences of criminal contempt and civil contempt, actually, unfortunately, in the family division, when someone fails to appear or when they're not complying with a law that has already been set, it can kind of take on a quasi-criminal nature. And they are afforded in the family division even an attorney to represent them before there's any, when there is a threat of incarceration. But certainly in the family division, we have a employment program, before someone, we're trying to get child support. So putting someone in jail, is kind of counterproductive. So there's an employment program that we regularly use. When I was practicing criminal law, if there was an opportunity for my client to go into an ARD program or some other, pre-conviction program, I was certainly, because you never know what's going to happen when you walk in a courtroom, no matter how good your case looks, I would certainly, present that alternative and, strongly, go over, the alternatives with my client and work out what's best for the client. But, again, when you're walking into a courtroom and you just don't know what's going to happen, that's when the pre-trial and diversionary measures become that much more valuable. Thank you.
Thank you. May I repeat the question, Mr. Scorpion?
You may.
What is your experience in working with pretrial services and diversionary programs? Do you support alternative sentencing programs? Why or why not?
First of all, I think that the best diversionary program is any type of program that diverts uh, our youth from ever having any encounters with the judicial system in the first place. Those are, again, community-related factors. We have to go where the kids are the most. They're most often at home. They're most often in school, in the churches, on the playgrounds, and on the basketball courts, in the fields, in the community. Incarceration should always be a last resort, especially when we're involving youth. Diversionary programs present a wonderful alternative. Again, I think before you decide on the correct diversionary program for the offender to participate in, you need to examine the circumstances that brought the youth into the courtroom in the first place. And a lot of that comes from listening. So I think that the first thing in any diversionary program should be that you listen to the youth, find out what they're about, find out what caused them to exhibit the behavior that's brought them to the courtroom.
Thank you. The next question, we will start with Mr. Scorpion, and it has to do with conflicts of interest. Magistrates work on a local level with their fellow community members, family, friends. How will you remain objective, and how will you handle conflicts of interest of those you know personally that happen to appear in your courtroom?
Well, the easy answer to how to avoid conflicts of interest, it would be to just recuse yourself, depending on the nature and the extent of and the degree of the relationship to either of the parties. I forgot the other part of the question. I'm so sorry.
No, that's fine. Just how would you remain objective, and how would you handle the conflict of interest?
Well, I addressed the conflict of interest, but again, everybody comes into court cloaked in the presumption of innocence. Everybody has an equal opportunity to be heard. Everybody starts off on the same footing, and the court's obligated to apply the law in a fair and impartial manner. In fact, the rules governing behavior by magisterial district judges requires that you exercise the application of the law in a fair and impartial manner without any recourse or without any resort to public clamor or outside influence. Certainly, the decisions that are made and the reason that magistrates are elected in a community-wise are so that you can get some input from the community, but not to be swayed by any decision-making.
Your time is up. Thank you. Thank you. May I repeat the question, Ms. Duncan?
Certainly, thank you.
Magistrates work on the local level with fellow community members, family, and friends. How will you remain objective, and how would you handle conflicts of interest of those you personally know that appear before you in your courtroom?
Thank you. And in this sense, I think, or I believe that the conflict of interest or any perceived conflict of interest, that lies with the parties coming before me. Personally, I can be fair, I can be impartial, unless we're talking about a close relative or something, someone like that, in which case I would probably know about it beforehand and I wouldn't bring it before me. I would, transfer it to another court. The magisterial district judge level is unique in that if someone walks into my courtroom, let's say I knew them by a nickname or something like that and didn't realize this was someone I knew, maybe went to high school with before they walked into my courtroom. One thing we can do at the magisterial district judge level is try to work it out. And these are, it's not always a criminal issue. It may be, two neighbors who are having a dispute. And I can say, what can we do to work this out? But if there was a perceived conflict of interest on the part of one of the parties, I want to promote their confidence in the courtroom. So even though I know that I can be fair and impartial, if either party perceived that, there was some, possibility that I could not, even though I could, I would recuse myself from that case. But otherwise, I have, full confidence in my ability to be objective, to look at the facts, and to assess the law as I am required to do. Thank you.
Thank you. The next one is sort of similar, and we'll start with you, Ms. Duncan. If you became aware of unethical conduct on the part of an attorney or a law enforcement official in a case in which you were presiding, how would you handle it?
Oh, I can make this one real short. I would have to report it to the proper authorities. There's no, again, my job is to conduct fair and impartial hearings, but also my job is to promote the public's confidence in our justice system. Now, I couldn't allow, any inappropriate behavior to occur in my courtroom and turn a blind eye to it. It's not me. That's not who I am. That's never, who I've been. And I will, my 89-year-old mother wouldn't appreciate that either. But I have a reputation to uphold, not only my own reputation, but the reputation of the court. So I would have no problem reporting it to the proper authorities.
Okay, thank you. I'll repeat the question, Mr. Scorpion. If you became aware of unethical conduct on the part of an attorney or a law enforcement official in a case in which you were presiding, how would you handle it?
I certainly would inform the proper authorities as to the nature of the improper conduct. In fact, the ethical canons compel us to report unethical conduct in an attempt to maintain the integrity of the court and of the judicial system as a whole. That's it.
Thank you. Thank you. The next one is regarding orders of protection, and we'll start with Mr. Scorpion. What factors do you deem most relevant when determining whether or not to grant an order of protection?
Certainly you would have to look at any history involved, look at the person who is applying for the order of protection, how they perceive the threat, because ultimately they're the ones that deserve and warrant the protection. So a very, very thorough discussion with the person seeking the protection order would be in order. A lot of times, though, unfortunately, protection orders aren't worth the paper they're written on. So to the extent that we can deal with the alleged offending party as well and emphasize to them the importance of complying with the order to maintain civility, then I would certainly be up for that.
Thank you. Ms. Duncan, this question states, what factors do you deem most relevant when determining whether or not to grant an order of protection?
Thank you. And at our level, what we would grant would be emergency protection orders. I had the pleasure, and again, I'm telling you, I'm trying to be proactive. I had the pleasure of sitting with one of my mentors, Judge Kathleen Mulligan, a few weeks ago to actually observe some of the PFA hearings. The first hurdle is to establish that there is a relationship. A protection from abuse order can't just be given to anyone. Like, it can't be given from one neighbor to a neighbor. There has to be some relationship, either marriage or a sexual relationship or something of that nature. So we have to establish first that that relationship exists, and then there has to be an establishment, through either credible testimony, because unfortunately with a PFA, sometimes it comes down to one person's word against the other person's word. But that's, I would have to assess whether or not the person who's applying for the protection from abuse has established that there is a danger, an immediate threat of danger in order to restrict someone, because you may be restricting someone from their own home. So but those two hurdles to get over: first, the relationship, and then the existence or the likelihood that some dangerous act is going to occur, that some form of abuse is going to occur, is what I would be looking for with each of those cases. Thank you.
Thank you. The next one involves your relationship with Common Pleas Court. And this would go to Ms. Duncan first.
Sure.
What is the standard of proof that must be reached in magisterial court to bind a person over for trial in a common pleas criminal court?
Well, what we're looking for at the magisterial district judge level is just to establish basically that that a crime has occurred, and then also that the likelihood that this person, the accused, actually committed the act. Now, we're not finding guilt or innocence, just enough evidence, enough information to hold it over to go into, to go to big court. So it's, it's very important for a defendant coming in at the magisterial district judge level to understand you're not going to be able to present a defense. And that's really hard. And when I was representing representing the accused in criminal cases at that level, it's hard for my clients to understand. Well, they wanted to speak out, they wanted to tell, their side of the story, but you don't get that you don't get that opportunity at the magisterial district judge level. You're just establishing, that the crime occurred and the likelihood that this is the person who did it, who committed the crime. And then it goes forward to common pleas court to when you get to that determination of guilt or innocence.
Thank you.
Thank you.
Mr. Scorpion, here's the question. What is the standard of proof that must be reached in magisterial court to bind a person over for trial in common pleas criminal court? Actually,
the threshold is very, very low in magisterial court. The threshold is whether it's more likely than not that the crime charged occurred and that the actor in front of the magistrate was the one who was involved in the matter. It's simple as that. It's again, a very, very low threshold.
Okay, thank you. And Mr. Scorpion, here's the next question. Describe a case or situation in a courtroom that you were involved in that tested your temperament and patience, and how did you handle it?
I represented some defendants over the years who were charged with unspeakable crimes. When I approached them after they sought me to represent them, I've confronted them by saying, look, if you did what you're charged with doing, I think you're the scum of the earth. I think you're the worst person in the world. I don't know that I find any redeemable facts in you, but having said all that, I'll give you the best representation that is available. And having said all that, I've never had a client walk away or say, no, you're not the one for me. Just the opposite. They've said, well, thanks for coming straight with me. I appreciate it. I know you'll do the job for me.
Thank you. Thank you. Ms. Duncan, here's the question. Describe a case or situation in a courtroom you were involved in that tested your temperament and patience, and how did you handle it?
Actually, the case that probably tested my temperament the most it wasn't the actions of the litigants. It wasn't the actions of the parties. It was actually the actions of the attorney. And in my 20 years, there's only been one time that I reported to, my manager, the managing hearing officer, who reported to the administrative judge that I would not allow an attorney in my courtroom again. And I had that, I did have that right and that authority to make that call. It was, we're there to promote the integrity of the court and the just the court, the public's confidence in the court. And you know, I just hate to say it. I just the client was not aware of what was supposed to happen in the proceedings, and I felt that this attorney made it very personal and just did not provide the representation that they should have. And I really hate to have to say that, but that is for, you know, to answer your question, that really is the one incident that tested my, you know, my temperament more than anything else. I conducted the hearing. I gave a fair and what I believe was the right, the correct and appropriate decision. But after that, I could not allow that type of behavior to happen in my courtroom again.
Thank you. Okay, this is going to be the last question, and then following this, we will move to closing statements. And we'll start with Ms. Duncan. After the murder of George Floyd, concerns about racism have been heightened in our entire country. How will you work in your court to ensure that everything is fair and equitable to people of all races, ethnicities, and genders who appear in your courtroom?
Thank you very much for that question. You know, we know that in our criminal division, sorry, at every decision-making point, there is a disparity in race. And, you know, it's from arrest to sentencing. It's been shown time and time again. We have to be aware of what's coming before us. We have to be aware of our own biases. I thank Judge Clark, and, you know, who's now our president judge, for requiring us to have ongoing, you know, sensitivity training and things of that nature. We have to constantly, you know, just pour into ourselves so that we, you know, aren't the ones causing the problem. But then, you know, back to, you know, your other question, when those problems come before us, we have a responsibility to report them, you know, to the proper authorities. But most of all, you know, we have we have to be aware. We have to be aware of what's coming in front of us. It's very personal to me. I welcome the opportunity to run a fair and impartial courtroom. And I also stand on the work that I did with the City of Pittsburgh Human Relations Commission to combat discrimination at all levels, not as my job, but that was my voluntary work. That's what, that's where I see a need in my community. So that's where I put my efforts for 10 years, including 4 years as the commission chairperson. Again, very personal, very, very dear to me, and just, you know, at the top of my priorities.
Thank you.
Thank you.
Mr. Scorpion, here's the issue. After the murder of George Floyd, concerns about racism have been heightened throughout our entire nation. How will you work to ensure in your court that it is fair and equitable to people of all races, ethnicities, and genders who will appear in your courtroom?
Well, certainly racism has no place in a court of law. And in fact, the laws and rules of procedure prohibit anything but a fair and impartial application of the law, regardless of considerations involving race, creed, sex, national origin. Again, I get back to the scales of justice, because that's a picture that everybody can relate to in their mind. The scales are balanced when you come into the courtroom. The Lady Justice is blindfolded for a reason. She's blind to everything except the letter of the law. She's blind to race, blind to color, blind to anything but the application of the law. Certainly, jurists at all levels need to leave any personal biases out of any decision making. And I can state firmly that I would have no problem handling myself in any of those situations if anybody would attempt to make race an issue in the courtroom.
Thank you very much. That is the end of the questions from the League of Women Voters, and we will move now to closing statements, and we'll start with Mr. Scorpion.
Thank you, and thank you to the League of Women Voters for presenting this opportunity to speak. It's important that we elect a magistrate in the 26th and 27th wards who will treat every person that comes before them with dignity and respect, and who will apply the law in a fair and impartial manner. Someone who knows how a magistrate's decision can affect not only the parties at issue, but also their families and the community at large. My family and professional experiences give me the ability to do that. And through my personal and professional experiences, I've learned that justice and resolution of disputes can most often best be achieved through a fair and even-handed application of the law, combined with a healthy dose of common sense. And that's the same kind of common sense that I obtained from growing up on the North Side and having lived many of the same experiences as our friends and neighbors. Because of my experience, I know what works and what doesn't work, and I'll be ready to work starting on day one. Again, I thank the League of Women Voters for this opportunity.
Thank you. Ms. Duncan, your closing statement, please.
Thank you. And I absolutely thank the League of Women Voters for this opportunity to speak with you and to speak with the community at large. I thank the North Side for the overwhelming vote of confidence in May that made me the Democratic nominee for Magisterial District Judge. I believe, and I won that nominee over 5 other candidates. I believe I won that nomination, and I won the confidence of the North Side based upon my experience, which is unlike any other. And also based upon my connection and my commitment to the community, which is also proven. I'm so proud that 3 of the other candidates who were in that race are now actively supporting and even promoting me for this position. And I'm so grateful for that. I'm grateful for their confidence in me. Excuse me. I am very happy to bring my skills, my skill level, my experience, my commitment, my love of the community back to the North Side where I grew up. I grew up in the 26th ward, live in the 27th ward. I've raised my children in the 27th ward. I'm committed to this community. I'm committed to justice. I am committed to taking everything that I've learned at the county level and bringing it to my community level. And also, again, as I stated before, I am so happy to learn that the entire school district for Pittsburgh would be coming to my district for truancy cases. I look forward to partnering with the community in that manner also. Thank you, League of Women Voters. Thank you again, North Side. And thank you, Mr. Scorpion, for participating in this forum. Thank you.
And now a closing statement from the League of Women Voters. On behalf of the League of Women Voters of Greater Pittsburgh, I want to thank our candidates for participating in this forum and thank the viewers for their interest in this very important race. Voters can obtain more election information on our website. Go to lwvpgh.org. That's lwvpgh.org. You will find a mini guide taken from Vote 411 that just will have these candidates' answers, written answers to our questions. You will find information on the statewide judicial candidates and a whole page on the county common pleas candidates. For information about every candidate on your ballot, go to our online voters guide at vote411.org. That's vote411.org. You just enter your home address and your whole ballot will come up. The deadline for registering or changing your address is October 18. The deadline for applying for a mail-in or absentee ballot is October 26. We encourage each of you to vote either by mail or in person on Election Day, Tuesday, November 2nd, from 7 a.m. to 8 p.m. This recording is the property of the League of Women Voters of Greater Pittsburgh and can be found in its entirety on the League's Facebook and YouTube pages. The public may share those recordings. Thank you for your interest in candidates running for this important office of Magisterial District Judge. Good night.
Good night.
Good night.